We were given a few minutes to take questions, so feel free to stand up and speak loudly.
Tender David, can you talk about what you feel is the time frame we're looking at here realistically? And first of all, we'll talk about that and I have a follow-up.
I don't think there's any way of really predicting when the court will decide, but it will certainly be a while. It will not be this year, but sometime, hopefully early next year.
And to follow up on that, both sides have basically said that if they lose, they would take it to the U.S. Supreme Court. So that seems to be a given. With that in mind, how far away are we from having Proposition 8 finally decided definitively once and for all? Are we still a year or so away, you think?
If it goes to the Supreme Court, if the Supreme Court accepts it, yes. And if they seek Supreme Court review, which they said they will when they lose, then there will be a period of time, 90 days, while they seek that, even if the Supreme Court were to deny it.
So worst case scenario as far as length, what do you figure?
Sometime in 2012.
On the standing issue, do you expect the California Supreme Court to get involved in this, as the judge suggested?
I think that if the court were to decide it on the standing issue, that is the least likely for the Supreme Court to take the case.
I'm talking about the state Supreme Court, I'm sorry, with the plaintiffs and the question of standing, and the whole issue of the governor and the attorney general.
Do I think they're going to certify it to the Supreme
Yes.
Court? I wouldn't want to try to opine on what the court's going to do.
What do you make of that? Those questions, though. What do you think that means? Were you surprised by that line of questioning?
No, because the Supreme Court and this court have said that a necessary but not sufficient condition of allowing somebody to intervene on behalf of the state is that the state specifically authorized them to do that. My argument to the court was, even if that had happened, and we don't think it has, that is not sufficient, and they still would not have the concrete, particularized, personal injury that the federal Constitution requires for standing, because they have absolutely no evidence that this hurts them in any way. And if it doesn't hurt them in any way, the Constitution says there's no case or controversy and they shouldn't be in court. So even if they were authorized to do that, a state can't authorize somebody to have federal court standing. So what I was saying was that we don't think there's any real doubt about the state law issue. The state has not authorized them. There's no law that says that. In fact, the Supreme Court said they do not have standing. Intervention is a different question. There's a little bit of confusion between intervention and standing. The standing issue is separate from the intervention issue. So we don't think there's a confusion about state law. But even if there was, we think that would not be sufficient.